Hello, I'm Patricia Kosim, Ontario's Information and Privacy Commissioner, and you're listening to Info Matters, a podcast about people, privacy, and access to information. We dive into conversations with people from all walks of life about privacy and access to information issues that matter to them. Welcome, listeners, to Season 5 of Info Matters. And what a better way to start us off than with our first guest of the new season, Elizabeth Denham, or Liz, as she is known to many, is currently the chair of the Jersey Data Protection Authority. She was the UK Information Commissioner from 2016 to November 2021. Liz was previously the Information and Privacy Commissioner for British Columbia, appointed in May 2010. And prior to her role as BC Commissioner, she was the Assistant Privacy Commissioner of Canada, where I had the great pleasure of working with her. Liz, I'm so excited to have you on this show.
Oh, it's great, Pat. I'm an active listener to your podcast. It's going to be a good conversation. I know it.
You and I first met in the early 2000s. We were both on an FPT, Health Information Working Group, that was working towards harmonizing health privacy laws to facilitate this vision of interoperable electronic health records across the country. I was at Canadian Institutes of Health Research at the time. Do you remember those days?
I do remember those days. I remember them fondly. I was working as a private consultant helping health authorities and health agencies comply with new provincial laws. We were both passionate, in particular, about health privacy and research. And it's fair to say, I suppose, that both of us cut our teeth on health privacy, and you were already an expert in privacy and health ethics. And I think a few more years passed, and our paths crossed again. We were both working for the Office of the Privacy Commissioner of Canada under Jennifer Stoddard. You were running the legal directorate, and I was the director of research and stakeholder relations. Remember that?
Yes.
And later, I was appointed Assistant Privacy Commissioner of Canada. And so I think both of us had, at that time in 2007, 2008, we had really broadened our privacy focus from health privacy to commercial privacy, to government privacy issues. And, we had the privilege really of regulating with a backdrop of disruptive technologies and novel issues that really were brought about by things like social media and mobile computing.
When you look at where we've come since, how much progress do you think we've made in achieving greater harmonization of privacy laws across the country?
I think most provinces are still trying to come to grips with electronic health records and interoperability. So when it comes to health privacy, we haven't got as far as I think we had predicted 25 years ago. And I think part of that is that the health sector creates really a thorny problem because health privacy is a patchwork across Canada with standalone health information laws like in Alberta and in Ontario. And then there's private sector and public sector privacy laws that apply in other jurisdictions. So I think those laws are really looking at health privacy through different lenses. But where there has been harmonization of approaches, I think, is between private sector laws.
I wonder to what extent the progress we've made in harmonizing private sector privacy laws was kind of incentivized by this provision in PIPEDA that excludes or exempts provincial private sector privacy laws that are substantially similar. So there's this built-in mechanism to drive harmonization, which has to a certain extent worked nationally. And internationally, the GDPR has a similar mechanism of adequacy to drive international harmonization, which it too has worked to some extent. But in the health sector, as you say, there isn't that same mechanism to drive health statutes to look or feel similar. And I do think that that's part of the constitutional reality of Canada and the division of powers. But what do you think about where we're at today in the current geopolitical context and this growing concern and interest to strengthen Canada's regulatory framework for new reasons, to facilitate the expansion of digital infrastructure, interprovincial trade, and there's a renewed enthusiasm, I think, to break down some of those barriers. And regulations are part of those barriers if they're not the same or they're not similar or harmonized, right?
You and I were chatting about this about a year ago, about how digital harmonization is a key part of successful and effective trade in this country. So I agree with you, but we need the political will to do that. And so it is going to take the attention of our leaders. And I certainly think that leaders like you at the Ontario office, I think leaders across Canada, privacy commissioners would be part of that leadership. So I hope for that. Let's be optimistic, because 25 years is a long time to wait, isn't it?
Yeah, it is. And it's interesting that there's a federal bill now that aims to regulate vendors of health information technology to ensure that it is interoperable and to prohibit data blocking in order to promote a connected, secure, and person-centered health system. So this is an interesting development, again, that might drive a little bit more consistency across the country. And hopefully this dream of interoperability will be facilitated as a result.
So, Pat, if I may, going back nostalgically to the early 2000s compared with today, what do you think are the biggest shifts in the data landscape in terms of how personal data is used and how society thinks about their privacy?
Well, certainly we've seen personal data now become absolutely indispensable as a commodity for fueling progress across all major sectors. If you think of commercial, health, education, justice, social services, across the board, right? And certainly there's been a shift from what was individual, transactional, purpose-driven uses of personal information to what are now much broader, more pervasive uses of personal data to derive general insights and inferences. And it's not just personal data that's valuable. De-identified data, too, has become a hot commodity. Only, as you know, de-identified data can still pose a risk to individual privacy and particularly group privacy if it's not done properly. Also, we've seen privacy become much more intertwined with other human rights. And we talk about privacy now as a gateway concept for exercising other fundamental rights and freedoms. If you think of freedom of expression, all of our online activity being a form of our freedom of expression, freedom of association, the right to participate in public protests without being filmed and facially recognized, and the right to vote freely and democratically without interference. I think those connections have become a lot clearer. When it comes to society's reasonable expectation of privacy over the 20 years, I think there was a time when we really wondered if people's reasonable expectation of privacy was being sort of diluted and forced downwards just because of this sense of helplessness with all of the surveillance technologies that have developed over the past 25 years. And I think that's certainly true, but I wonder if the pendulum isn't starting to swing back a little bit. I mean, we're seeing strong affirmations of the right to privacy by the Supreme Court of Canada in R versus Bickovitz, and we'll see what they have to say in the Facebook case that was just heard last week. So I do think that although it started to get diluted, I'm hopeful that increasingly we're starting to see the reasonable expectation bounce back as it should, rightfully, as society realizes just how much is fundamentally at stake. What do you think, Liz?
I think that you and I have been around long enough that we can see some very specific inflection points. So if you think about it, 9/11 hugely shifted societal and government concerns to public safety, and I think normalized surveillance to a certain extent. And then along comes the Snowden revelations in 2013, which I think really heightened issues of privacy in the public's mind. And so there's the pendulum that you referred to. And then in 2017, 2018, the big case being Cambridge Analytica and Facebook. And that really underscored for people, and they could see for the first time how intensive data surveillance could compromise free and fair elections. I see some of those big cases and incidents as being really the cause of the public looking again at their privacy rights. I do think those inflection points are important. Same law, different environment.
You're so uniquely placed because you've been assistant commissioner federally in Canada, you've been provincial commissioner in BC, and then, of course, you were commissioner at the UK Information Commissioner's Office and sat as the chair of the Global Privacy Assembly. And so you've really had a front row seat to the evolution of modern data protection regimes at a global level. How do you say we compare in Canada to the rest of the world?
Sidestepping the question just for a moment, my UK term as Information Commissioner was truly a stretch assignment for me, Pat, because I went from a fairly small office I was leading in BC to a much bigger national regulator. I was running one of the largest regulatory offices in Britain as a Canadian running this. My job was also to bring in an EU regulation when the country had just voted to leave the European Union. That took 4 years. But if you set aside the political drama of Brexit, it was truly a privilege to administer such a comprehensive law that had real penalties, real sanctions, and the resources to do the work well. My years as chair of the Global Privacy Assembly, the organization that brings together all of the data protection authorities around the world, 130 of them, really gave me an incredible insider's view to different regimes, different cultures, different legal systems and approaches to privacy. We focused on what brought us together rather than what set us apart. And I have to say that I used all the lessons that I learned in Canada across federal and provincial offices to apply that kind of inclusiveness that we needed to see at the global level. But getting to your question, how do Canada's laws compare to the UK and other countries that have modernized their laws? We have lagged behind. We've been lapped. We are still waiting for law reform at the federal level, also at the provincial level. Many commissioners in Canada are still ombudsmen. They don't have order-making powers, let alone sanction powers. But when it comes to leadership and influence, Canada really shines. Philippe Dufresne is now the chair of the Global Privacy Assembly. You and your office are very active on the international scene, speaking at conferences, leading in interpretive guidance. Ontario is a really big player internationally, so is BC. And for many years in BC, they chaired the Asia Pacific Privacy Authorities. So I would say high score for influence and leadership, a much lower score for modernization of the law. And I hope it's coming soon.
I couldn't agree with you more in terms of our influence. Definitely, Canada played an important role and continues to. And I love the fact that we do punch above our weight. When you think of all the federal and all the provincial and territorial offices collectively, I think we do have significant influence. And I'm so happy and proud to see the provinces at the table, along with the federal commissioner, because it just strengthens and amplifies our voice. And particularly, we're able to complete Canada's role in areas of provincial jurisdiction. So I think it gives us an opportunity to show a united front and to have that kind of influence that you're speaking of, Liz, because we do collaborate extremely well together. And if our laws aren't the model laws internationally that we would hope for, at least, as you say, we're able to express that voice and that advocacy on behalf of Canada, which is really great.
And it really was Canada that brought some of those core principles that we all include in our laws and made their way into more comprehensive laws. Accountability,
Mm-hmm.
that's a Canadian concept that's in our federal law. Privacy by design, which has become a requirement in the GDPR, those are Canadian concepts. And so we still lead in those areas. I mean, I remember back when you and I were at the OPC and we wrote Getting Accountability Right with a privacy management program. And that guidance was replicated around the world. I remember working with the Hong Kong office on that. So I think Canadians are extremely well respected. We have great diplomatic skills. And I think we step up and punch above our weight, as you say. I was thinking about our conversation today, Patricia, and of course, one of the biggest developments shaping the conversation right now and at every conference is artificial intelligence. And I wanted to ask you how you are addressing these developments in Ontario. I've seen some of the guidance that you've written, and it's been excellent. But what's your focus when it comes to artificial intelligence?
Well, it's interesting because in Ontario, the government adopted an act called Enhancing Digital Security and Trust Act in November 2024. And the law is framework law in the sense that it gives government and the minister authority to adopt regulations or directives or technical standards on AI. But as of yet, those don't exist. So the law really is inoperative until such time as these regulations or directives or standards are adopted. And so it's been quite a while since November 2024. And to fill that gap and to provide the public sector with some guidance, it was really important for our office to work with the Ontario Human Rights Commission to publish these guardrails for the use of AI in public sector that urges the adopters and developers of AI to ensure that it's valid and reliable, that it's safe, that it's privacy protective, that it's human rights affirming, transparent, and accountable, so that we can tell public sector how they can innovate and experiment with AI while still complying with existing privacy and human rights laws. And I'm so pleased that we had this collaboration with the Ontario Human Rights Commission because it goes to something very important, and that is the importance of increasing cooperation and collaboration between different regulators. We talked about, between different data protection commissioners at the federal, provincial, territorial level, but now we've really expanded and recognized the need in this digital era to increase cooperation with other regulators, where we're really speaking with one voice and making it easy for public sector to reconcile their need for innovation and experimentation and improvement of government services, but also to have some guideposts and some guardrails to know how they can also respect privacy and human rights laws at the same time. This is something I think you've done a lot of at the UK ICO. I'm wondering if you can comment a little bit on the cooperation you forged with other regulators there.
I mean, you're underscoring how important it is to look outside your boundaries and recognize your sister legislation. That's fantastic work with the Human Rights Commission. In my years at the ICO, we created the Digital Regulators Cooperation Forum, and that cooperation was really geared at private sector platforms. Competition authority, really important to look at how competition or antitrust authority is looking at these big platforms, as well as privacy authorities, as well as a communication regulator and financial services regulator. So created this forum, which is not a tea and sandwich club. It is a real working forum. Staff are seconded to the forum. What they're trying to do, instead of having the government, as it once did, thought of establishing a new AI regulator, existing regulators could show how their collaboration would actually meet those goals rather than putting yet another regulator on top of them. And I think the companies that were overseen by these individual digital regulators benefit from that. I think that Digital Regulators Cooperation Forum will eventually make its way onto the statute books. For now, it's doing wonderful work and it's being replicated partly in Canada, some of the efforts by Philippe Dufresne to bring together these same regulators. Australia has followed suit. Working together is the only way forward, and it is beneficial to citizens so that they can focus where their rights are in a particular circumstance. And I think that's really, really important.
As a commissioner in Ontario, now into my second mandate, I set out a vision for the office to be a modern and effective regulator with real-world impact. And I know that's something that resonates with you because you modeled that so well in the novel regulatory approaches you experimented with at the UK ICO. And so I wanted to ask you, what do you think it means to be a modern regulator with real world impact?
Well, first of all, I had the privilege of bringing in and administering a first in a generation upgrade of data protection law. It had been 25 years, arguably, since the UK law had been reformed. So all those new powers in the law, Patricia, sanctions and fines, statutory codes of practice, ability to compel witnesses and seize data in the cloud, stop processing orders, all of those tools really we needed to help make us a regulator with real world impact. In other words, a true digital regulator.
Mm-hmm.
And I think because of that law, the C-suite in companies and the executive in public bodies really took account, I would say for the first time, of privacy and cybersecurity and really resourced it because of the possible threat of enforcement action. It was the new law and the powers that were given to the ICO that provided a lot of the tools we needed. And it's not that you have to use fines all the time, but the threat of fines and the judicious use of them, I think, was really important. But as you say, the ICO is the largest data protection in the world. Its budget, which is based on fees collected by companies and public bodies, allowed for some of the innovation that we were able to put in place. So running a sandbox for developers to beta test novel uses of data. Let's try it. The grant program that we funded to public interest research based on the OPC's grants and contribution program that we both knew, specialty advisory committees like a committee of technologists that could give us advice, and hiring people with diverse skills and backgrounds. That was super important at the ICO. So technologists, economists, people with specific industry expertise, and a secondment program where we brought in people from banking and financial services and tech companies and law firms, life sciences. And I think that really helped us enormously to better understand the sectors that we regulated and how business models actually work in the private sector. So that was super important. And I think that's what helped the ICO to be seen in a different way, not as the Department of No, but rather an agency that saw the positive side of technology and economic benefits and retaining a clear eye to the red lines that matter to people. So what about you, Patricia? What do you think modern regulators need in the years ahead?
When I talk about being a modern and effective regulator with real world impact, first of all, that's a long phrase to print on a t-shirt, but it's also kind of a complicated notion to boil down, but it's starting to take shape, I think, and it's starting to reveal itself through some of the initiatives and successes we're having as an organization. And when my staff ask me, are there models out there that you look to in implementing this vision? And I've told them I look to the UK ICO for many of the examples that you just gave. And there's so much, as you know, that can be done in terms of proactive initiatives. If we just let ourselves be swallowed up by complaints and appeals, we can never sort of get our heads above water to initiate some of these more novel ways of actually having impact and influence. And so, one of the first things we need to do is be much more strategic with the kinds of complaints and appeals we take on in order to liberate our resources for some of these other initiatives. Compared to the UK ICO, we're much smaller, of course, and we don't have independent funding. We're very judicious with the budget that we do have. Some of the things that it's meant for us has been to develop a research program. We do have in our mandate to commission research on emerging technologies. And so we're starting to, on a more systematic basis, identify each year research in novel emerging technologies and getting the best people in Ontario or Canada to give us the lay of the land. We've developed a scholar in residence program where we bring a well-renowned scholar in-house to work with staff in areas of ultra expertise. We had Dr. Teresa Scaza as our first one, Dr. Ella Mam as our second, and we're about to announce our third. And this has been tremendously helpful in strengthening our internal capacity and to deal with some of very important emerging areas. We take a much more risk-based approach to our enforcement, to our oversight, to our reviews. I think that's important, again, focusing on where the real risks are as opposed to spreading and diluting our oversight and our resources. And I think the investments that we've made and continue to make in our technology experts has been extremely important because, as you know, that really means speaking with knowledge and credibility and having influence and authority. So I think capacity building has been very important to be modern and effective so that you can be enabling of innovations within appropriate guardrails.
What that means is hearing other voices.
Mm-hmm.
I think of your children's council, for example. I mean,
Yes.
that has been, I think, a very, very important and strong initiative for you to have children's voices considering the work that you've done on EdTech, for example, to hear from children themselves on what they think and feel. And that's just a critically important area. And just like you, I have been very much focused in my career on children's privacy and continue to be.
The Youth Advisory Council is a great example, Liz, of doing something novel. I think we were the first data protection authority in the world to have a standing youth advisory council. They're in their fourth year already, and they've evolved to be such an important resource for us in terms of advancing our children and youth advocacy work and education and in schools. Another example I would use is our transparency showcase, which is really about celebrating good examples of transparency and not always coming down hard on organizations or institutions that get it wrong, but actually shining a light on examples that get it right and hopefully inspiring others to follow suit. So I think that's been a really different and hopefully novel way of bringing about change and influence and greater compliance in the end, right? That's what we all want.
Those are really good examples of some of the upstream work that you can do to really make people understand what their obligations are, but also that privacy laws are not a handcuff to
Exactly.
innovation. So I think that the upstream work is really, really important. Like many offices in Canada and elsewhere, your office has a dual mandate overseeing both freedom of information and privacy. So could we talk a little bit about some of the unique challenges and maybe the opportunities in holding both of those roles?
I can see the benefits of the combined mandate. And in particular, there are such important intersections between data protection and privacy and access to information and transparency. So many times, the issues that the public or requesters want access to involve the personal information of others. And therefore, it's very important to balance those rights and be able to come up with a well-reasoned resolution that advances and protects both rights of access and privacy. I think also it's important to think about data regulation in the broader scheme, not just data protection, but information as such an important asset to advancing democracy, advancing objectives of transparency, and to be able to have mandate over both of those aspects of data or information regulation, I think, is a very privileged position to be in. But it can pose some challenges as well in terms of resourcing both, making sure you're balancing both mandates with equal force, equal attention, equal resourcing. Just as a recent example, there are recent proposals to change our Freedom of Information and Protection of Privacy Act that will significantly impact the rights of Ontarians. And at first blush, they seem to affect access to information rights, but there are fundamentally important changes and impacts to their privacy rights as well. And so to be able to advocate for a strong regime that does both in a well-balanced way, I think is really important. As I said, because you have that dual mandate, you can be much more balanced about ensuring that both get equal consideration and are weighed and thought through very carefully to come up with the appropriate balance in the end.
I violently agree with you that it is advantageous, arguably for the public, to have one office that is overseeing both of those important objectives. And it's interesting to see Europe, where sometimes those roles are together in one office, sometimes they are separated. But in Australia and New Zealand and Canada, I think we have had that tradition with the exception of the federal level. On a more pragmatic level, what helped me when I had both mandates, and that's at the ICO and in BC, privacy got you in the door to talk to politicians, whereas governments in power do not like freedom of information legislation. It's just the way of the world. So by having both, I think you could be more influential. But I worry deeply now about proposals like the one the Ontario government has put forward. I worry about the proposal that's put forward in British Columbia, again, to dilute the rights of citizens. When you think about freedom of information and freedom of information rights, I mean, they are up there with Hansard and question period and all of these very important tools that citizens need to be able to hold their governments to account. So I'm a deep believer in retaining those strong rights.
When you propose to take rights away, I think that's what really focuses the mind, and people understand after almost 40 years, whether they've exercised those access to information rights themselves or they've relied on intermediaries like journalists and the media and researchers and opposition parties to get access to information to be able to keep citizens informed and to hold their governments to account. And what better and more important time than now in the current context, certainly, to uphold those rights and to uphold the integrity of institutions that oversee those rights, to ensure that we stand as a model internationally of democracy and we don't revert backwards, unfortunately, to the lowest common denominator. So I couldn't agree with you more. So, Elizabeth, you've had a very long and distinguished career in access and privacy regulation, which I certainly and many others admire. What gets you up in the morning now and continues to motivate you and energize your work in this space after all these years?
I always felt, Patricia, that the work is so urgent. the stakes are so high. I mean, think of what we just talked about, freedom of information, protection of privacy. The tech has and is moving so fast. The companies are so large. And I do think it's easy to feel like you're outgunned. But the mandate is very much worth defending because it affects people's lives. It's real. And there's always shifting government priorities and the need to remind them of the value of this law and the value of this practice. I think the other thing that gets me up in the morning is the fascination of the work. So, privacy, for example, sits right at the intersection of society and law and technology. Children's privacy and election integrity were topics that meant, I suppose, the most to me. And I'm still able to contribute to that work. And that brings a lot of vigor to my days. And I suppose the last point would be the people. There's really just a small group of people that are regulating these laws around the world. So there's a tight community, friendships and colleagues, and just seeing people around the world where you're all striving towards the same thing. My mother is 92 and she keeps asking me when I'm going to retire. But my kids and grandkids can't see that happening anytime soon. I mean, there's never been a more interesting time to be regulating, to be working on policy issues. I think they're right. I can't see an end anytime soon. What about you, Patricia? What gets you up in the morning? What gives you the most optimism?
Just going back to our Youth Advisory Council, they give me such optimism to hear young folks be so impassioned about these issues, gives me great optimism for the future generation and their interest in fashioning their own future, taking matters into hand and really being proponents in this play as opposed to sitting back and watching it happen for them. I also feel a lot of optimism when I think about the next generation of leaders in this space, in early to mid-career, and I see them so engaged, particularly the women, actually, so knowledgeable and growing increasingly sophisticated about these issues and able to articulate them and really play pivotal roles within their organizations and their institutions to speak about these issues and to influence major decisions. And I think that that's something we're seeing more of. Whereas before, maybe chief privacy officers were secondary roles or not listened to as much. I still think they need to have more of a central role, but I think that is happening because everybody is growing alive to how important these issues are to the viability and the sustainability and the success of organizations and institutions. And the last thing I would say, although these recent legislative proposals in Ontario don't make me particularly optimistic about where things might be heading in the future, particularly if they're enacted as proposed, I have been very heartened by all of the voices that have spoken out and really explained to Ontarians what the ramifications and the implications are. And to hear all those voices chime in and express a view and participate in the public debate gives me tremendous optimism. Whatever may come of the legislative proposal, I think the fact that as a society we can have debates and discussions and disagreements about it is important, I think, for democracy and for the future of our laws. So that gives me quite a bit of optimism as well.
So here's to the next 25 years.
Yes. And I just want to say thank you so much, Liz, for taking the time as our first guest of season 5. What a way to start off the season. I enjoy speaking with you so much, as always. And this time in a public forum, because we have these conversations all the time and they fill me with great energy and enthusiasm. And I just want to thank you so much for the work that you've done for Canada, internationally, and continue to do. You're a great inspiration to many of us, Liz.
Oh, it's been a pleasure. And thank you so much, Pat. And we have to get on to writing that op-ed now.
That's right. We've got a lot of material that we talked about today. I think we can certainly use some of it.
Really good. Thank you so much.
Thank you, Liz.
I'm Patricia Kassim, Ontario's Information and Privacy Commissioner, and this has been the Info Matters podcast. If you enjoyed the show, leave us a rating or a review. If there's an access to information or privacy topic you'd like us to explore on a future episode, we'd love to hear from you. You can comment on our posts on Blue Sky and LinkedIn, or email your ideas to podcast@ipc.on.ca. Thanks for listening, and please join us again for more conversations about people, privacy, and access to information. If it matters to you, it matters to me.